Good morning, sir. Have a good day. I am Can Hendrix Arquerona, and this is my final examination in criminal procedure and court testimony. I discuss what I learned from Rule 119 to Rule 126. Rule 119, Trial. Trial is the examination before a competent tribunal of the facts put in issue for the purpose of determining such issue. Section 1. Time to prepare for trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. The trial shall commence within 30 days from receipt of the pre-trial. Section trial, not a bar to provision on speedy trial in the Constitution. No provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 3 of the 1987 Constitution. Section 16. Trial of several accused. When two or more accused or jointly charged with an offense, they shall be tried jointly unless the court, in its discretion and upon motion of the prosecutor or any accused, orders separate trial for one or more accused. Next is Rule 120, Judgment. Judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charge and the imposition of him the proper penalty and civil liability if any. It must be written in the official language personally and him and shall contain clearly and distinctly a statement of the facts and the law upon which it is based. Section 8. Entry of judgment. After a judgment has become a final, it shall be entered in accordance with Rule 36. Section 9. Existing provision governing suspension of sentence. Probation and parole not affected by this rule. Nothing in this rule shall affect in existing provisions in the laws governing suspension of sentence, probation, or parole. Rule 121. New trial or reconsideration. New trial or reconsideration at any time before a judgment of conviction becomes final, the court may, on motion of the accused or its own instance, but when the consent of the accused, grant a new trial or reconsideration. Section 3. Ground for reconsideration. The court shall grant reconsideration on the ground of errors of law or fact in the judgment, which requires no further proceedings. Rule 122. Appeal. Section 1. Who may appeal? Any party may appeal from a judgment or final order unless the accused will be placed in double jeopardy. Section 2. Where to appeal? The appeal may be taken as follows. A. To regional trial court in cases decided by the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court or Municipal Circuit Trial Court. B. To the Court of Appeals or to the Supreme Court in the proper cases provided by law in cases decided by the Regional Trial Court. And C. To the Supreme Court in cases decided by the Court of Appeals. Section 5. Waiver of notice. The appellee may waive his right to a notice that an appeal has been taken. The appellate court may, in discretion, entertain an appeal notwithstanding failure to give such notice if the interest of justice so require. Next is Rule 123. Procedure in the municipal trial courts Section 1, uniform procedure. The procedure to be absorbed in the Metropolitan Trial Courts, Municipal Trial Courts, and Municipal Circuit Trial Courts shall be the same as in the regular trial courts, except where a particular provision applies only to either of said courts and in criminal cases governed by the revised rule of summary procedure. Next is Rule 124, Procedure in the Court of Appeals. Section 1. The case in all criminal cases appealed to the Court of Appeals, the party appealing the case shall be called the appellant, and the adverse party called appellee. But the title of the case shall remain as it was in the court of origin. Section 3. When brief of when 30 days from receipt by the appellant or his counsel of the notice from the clerk of the Court of Appeals that the evidence or oral and documentary, the appellant shall file 7 copies of his brief and be accompanied by proof of service of 2 copies by the appellee. Section 14. Motion for new trial. Any time after the appeal from the lower court has been perfect and the judgment of the Court of Appeals convicting the appellant becomes final, the new trial on the move of new trial on the ground of newly discovered evidence material. Next is Rule 125, Procedure in Supreme Court. Section 1, Uniform Procedure, unless otherwise provided by the Constitution or by law. The procedure in the Supreme Court in origin in the appeal cases shall be the same as the Court of Appeals. Next is Rule 126, Search and Seizures. Section 1, Search Warrant defined. A search warrant is an order in writing issue in the name of the people of the Philippines by signed a judge and directed the peace officer, commanding him to search for personal property described in the court. Section 6, Issuance and form of search warrant. If the judge is satisfied of the existence of the facts upon which the application is based or that there is probable cause to believe that they exist, he shall issue the warrant, which must be substantially in the forms of prescribed by these rules. Section 9. Time of making search. The warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case in the direction may be asserted and served at any time of the day or night. Next is Section 10, Validity of search warrant. A search warrant shall be valid for 10 days from its dates. Thereafter, it shall be void. That's all, sir. Thank you po.